Hi guys, and welcome back to Contract B. This is part 2 video for the week 2 key concept videos. In this video we're going to be having a look at misleading or deceptive conduct under the Competition and Consumer Act 2010, which is, as we all know, Commonwealth legislation. So turning to the legislation now, we have the Act in all its glory there for you up on screen. I didn't know whether you had had a chance to have a look at the provisions of the Australian Consumer Law before, just on the off chance that you have not and you haven't had to actually go and find the thing. You will note that it is located down the bottom of the Competition and Consumer Act on AUSLI as Schedule 2. You can see down there, Schedule 2, Australian Consumer Law. So if you click on that, you will get the compendium of the complete Australian Consumer Law as Schedule 2. And the sections that we will be encountering will largely come from this schedule, although there are a couple that we need to look at that lie in the actual main body of the Competition and Consumer Act. Now, one of those provisions that does lie within the main body of the Competition and Consumer Act is Section 131, and that's probably our first port of call. As a Commonwealth instrument, generally speaking, the Competition and Consumer Act will apply to corporations, and notwithstanding that it actually does mention persons here and there throughout the legislation, you'll see in Section 131, Schedule 2 applies to the conduct of corporations. Okay, now it's going to only apply to persons, that is individual natural persons, in a fairly limited range of circumstances. Now those limited range of circumstances are set out for us in Section 6 of the main Act, and it says, without prejudice to anything else, the Act also has effect under this section and where people are trading between Australia and places outside Australia, so international trade, trade between the states, within a territory, between a state and territory, between two territories, then a person will be captured under this particular instrument. In addition, if you look down further, for Part 2-1, which is where Section 18 of the Australian Consumer Law is housed, it will capture persons where they engage in conduct in relation to postal, telegraphic or telephonic services or radio or TV broadcasts. So where the conduct is being engaged in via a communication service that is regulated by the Commonwealth, then the person as a natural person will be captured by the legislation. So they are the provisions that dictate how widely this legislation can reach to natural persons of itself. The beauty of this particular iteration of our consumer laws is that in 2010, mirroring legislation was enacted by each and every state and territory. And so therefore the legislation applies not just as Commonwealth legislation, but also as state and territory legislation. And obviously states and territories aren't limited by the Constitution as the Commonwealth is, and they can more than happily legislate away in relation to natural persons that are domiciled within their jurisdiction, carry on business within their jurisdiction and so forth. So you can either have the Australian Consumer Law being applied as a Commonwealth instrument or as a state or territory instrument, as the case may be, where you are looking at regulating the conduct of natural persons. The other couple of issues that we need to just be across here in terms of application of the Act is that government entities can be caught. So government's not immune from this legislation. Certainly where the conduct of the government really results in it carrying on a business much like anyone else, they will be caught. The other thing is, if you are making misstatements on behalf of a corporation, then you yourself as a natural person might be caught under the provisions that deal with accessorial liability. And you will see the Act defines a person in Section 2 as a person involved in a contravention if, and then you've got all the usual accessorial provisions, aiding, abetting, counselling, procuring, inducing the contravention, being directly or indirectly knowingly concerned in it, or you have conspired with others to be naughty and contravene the legislation. So you may well find yourself in the hot seat even though you are acting effectively on behalf of a corporation. So they are the application provisions. So the next thing we need to do is look at the elements of an action under Section 18. So turning back to Section 18, here we are, and it says a person must not, in trade or commerce, engage in conduct that is misleading or deceptive or is likely to mislead or deceive. We've already talked about the issue of who exactly is a person. It can be a company, it can be a natural person, it can be a natural person under the accessorial liability provisions. Must not, in trade or commerce. Now, if we jump back to the main body of the legislation and we look at the interpretation provisions, we look down here at trade or commerce. Means trade or commerce within Australia or between Australia and places outside Australia. However, if we then skip back to the Australian Consumer Law, and we're back here now, and you look at the interpretation provisions there, you'll see there's another definition of trade or commerce. And it essentially duplicates what was in the main body of the legislation, but clarifies here that it includes any business or professional activity whether or not carried on for profit. And that was really just intended to clarify some debate that had been happening around things like whether or not the legislation was intended to reach to professionals in their professional capacity. There was some argument that lawyers like you and me, from days of old, there was said to be some sense of altruism in our particular profession, and whether or not that would really be classed as hard-nosed trade or commerce. The answer is now obviously yes. So lawyers, accountants, professionals are all considered to be carrying on trade and operating in commerce. There was also some uncertainty as to whether or not not-for-profits, charities, were considered to be trading entities for the purposes of the legislation. There was no clarification in the past iteration of consumer legislation, and so now here we have non-profits clearly being captured by the legislation. So as far as what the court will consider to be conduct in trade or commerce, really you've just got to use your common sense. Is it the kind of activity that has some kind of commercial flavour? Generally speaking, where it's in business, concrete constructions, and Nelson said where it's got that commercial character, it's going to be captured as trade or commerce, conduct in trade or commerce. Things that won't be captured, purely domestic transactions, familial transactions, that kind of thing. The government won't be caught. Unless, as we said before, its activities are tantamount to carrying on a business. So you'll find often where government now has privatised its functions and it is essentially carrying on as a corporation, then that kind of conduct will be caught. Other than that, purely governmental activities will not be caught by the legislation. So then if we skip back to the Australian Consumer Law and we go down to our familiar friend Section 18, the next thing that has to happen is that there must be some kind of conduct, engage in conduct. And if you have a little look at the definition of conduct. And by section 2 here, it's a little bit confusing, but the text actually means, if you skip back to section 4 in the main body of the legislation and then you go down to sub-paragraph 2 of section 4, you'll see that a reference to engaging in conduct is doing something or refusing to do any act. And this, of course, has some bearing on whether or not silence will be capable of constituting an actionable misstatement for the purposes of section 18. We'll talk about that in just a minute. So the next thing, if we go back to the Australian Consumer Law, and here we are, we've engaged in conduct. What is the conduct that has to be engaged in? It's either misleading or deceptive, or likely to mislead or deceive. The thing I want you to take away from that is that you don't have to actually show that anybody was misled or deceived. It's sufficient that the person was likely misled or deceived. Now, in relation to what will constitute misleading or deceptive conduct, you'll see the text talks about a case called Campbell and Back Office Investments. In that case, Chief Justice French said that you have to consider the conduct as a whole. Okay, you can't just focus in as a fine point on one particular thing. You have to look at all the circumstances and weigh them up, as the courts normally do with this kind of thing. And you have to be able to conclude that as a sum of everything that's gone on, that the conduct at issue was likely to mislead or deceive. It would tend to lead a person into error. Okay, now who is the person that we're talking about? We are talking about the class of persons that are exposed to this particular misleading or deceptive conduct. It just has to be a reasonable or ordinary member of that class, according to a case called Campermar Sociedad. Interestingly, the past few years seem to have tightened up this requirement somewhat and do now require that the person protected be acting as a reasonable or ordinary member of the class. In years gone by, there was a case called Morning Star, and the judge in that case rather unpolitically correctly said that the legislation is intended to protect everyone but a moron in a hurry. You don't hear those kinds of comments much anymore nowadays. Most of the discussion tends to be centred around the reasonable or ordinary member of the class. It doesn't matter if the chances of being misled are less than 50%, more than 50%. What you've got to do, as I said before, according to the Campermar case, is look at all the circumstances and conclude that there was a real and not remote chance of the consumer being misled. So the Campermar case was rather interesting. It was held that the consumer there was not acting reasonably when they stated that they thought that, according to Australian branding laws, anything pretty much with the word Nike emblazoned on the goods or services somewhere must have been endorsed by the actual Nike sporting goods manufacturer. So this included things like pet food and toilet cleaner. They thought would have to have been endorsed by Nike if it had Nike on those goods. Court held not reasonable, rather extreme kind of assumption there by the consumer. However, if the misstatement is not directed, generally speaking, to a class of persons, but is directed to a specific person, then the appropriate test there is going to be, what would the reasonable person standing in the shoes of the targeted person what would they think? Would they be misled? Would they have been led into error? If so, then the conduct will fall within the ambit of the legislation. And that was according to a case called Downey and Carlson Hotels. There's no need for anyone to actually have been misled or deceived, as I said before. It's sufficient that there is a likelihood. You don't have to worry about intention here. The focus really is on the effect of the conduct that has gone on and whether the sum total of the effect would be likely to lead the relevant consumer or consumers into error. So you can engage in misleading or deceptive conduct even where you haven't meant to. So you may have made a misstatement quite innocently. That's really not going to get you out of any bother if the effect of what you've said would be to lead someone into error. The next thing that we need to look at is the kind of representation that's made. And we don't really need to labour this point because it kind of parallels all of the discussions that we had in relation to the common law of misrepresentation. But we'll briefly just touch on the various issues to refresh our memories and see what the position is like under the legislation. Now, the first issue that the text talks about is silence. And if you skip back to the main body of the legislation in the interpretation provision, section 4 sub 2, conduct is doing or refusing to do any act. And where you have someone refraining from speaking up, then that conduct is going to include silence. Now, the Act doesn't require you to speak up in all circumstances. Obviously, as with the common law of misrepresentation, there still has to be a place for things like caveat emptor to operate in. So you are quite entitled to keep mum, to keep quiet about certain issues, but you have this overriding restraint in that you can't keep quiet if to do so would be to convey a wrong or mistaken impression, or to give the idea that there was really nothing wrong or unusual with the transaction, nothing exceptional to note. Now, where your silence results in those kinds of impressions in the consumer, then it's more than likely the consumer is going to be led into error and you're going to have an actual misstatement under Section 18. What really Section 18 and the interpretation provisions kind of encourage is a minimum level of probity. It doesn't require an absolute disclosure of everything that's relevant to the transaction, like perhaps contracts ubere fide, those insurance contracts that we had a look at in the common law of misrepresentation. The test is simply, was there a reasonable expectation that whatever was not disclosed should have been disclosed? Now, if there is that reasonable expectation, as they held in a case called Miller and BMW, then you're going to have to speak up, okay? Pretty simple test and pretty simple guidelines, really. It's just common sense. If you're giving a half-truth or something that's going to give the wrong impression, something that's going to lead somebody else into error, then more than likely you will need to speak up. Just commercial probity. A couple of cases that kind of flesh this concept out a little bit more. The first one, as I said, Miller and BMW. Here we had reliance on what was effectively silence, I guess, as an actual misstatement. And the court actually found that there was no misleading or deceptive conduct in the surrounding circumstances. What had happened was a company had engaged Miller as their insurance agent to negotiate on their behalf with BMW Finance, who were going to provide some money to pay for an insurance policy that the company wanted to take out. Now, Miller started these negotiations with BMW. The initial negotiations broke down. BMW denied the finance application, and that was how things were left for a short while until the renegotiation of the whole deal on shorter terms that BMW wanted. As part of the renegotiation, the company actually changed the policy, the insurance policy that it wanted to take out with the money that it was going to get from BMW. Now, this particular policy had a number of risks that were a bit unusual, and also there was the additional fact that the policy couldn't be cancelled. Now, in the correspondence between Miller, the insurance agent, and BMW, Miller just sent a whole heap of documentation to BMW and said, here are the relevant documents. What Miller did not do was point out specifically the quirks of the new insurance policy. He certainly didn't point out that the new policy was not capable of cancellation. The question there, upon BMW making application to court because they wanted to get out of this finance contract, was should Miller have disclosed these quirky aspects in relation to the deal? And the court said, well, no, not really. There's got to be some capacity for a party to negotiate in their own best interests. Miller hadn't done anything wrong. The parties, each of the parties, both Miller, the insurance agent, and certainly BMW Finance, were sophisticated parties. They'd been through this routine many, many times before. It was a large transaction, and so BMW should have taken the time to read everything that Miller sent to them very carefully in a detailed fashion. The court found that whilst Miller didn't actually disclose that the new insurance policy couldn't be cancelled, nevertheless, because there was nothing in the documents that were sent that outlined the nature of the risks that were going to be taken, the court said that BMW was effectively put on notice as to ask more questions about the policy and what was to be covered, and things like cancellation, if they were going to properly satisfy their own interests and protect their own interests in the transaction. So Miller was not found guilty of any misleading or deceptive conduct. The other kind of bookend case to this, on the flip side of the coin, is the Noor Al Huda case. And in that case, it was for a sale and purchase of land. The seller certainly knew that the purchaser was going to buy the land in order to construct a school. And in those circumstances, the seller did not disclose the fact that the land was contaminated. Despite providing all this other ancillary information, they withheld that rather crucial snippet of information. Obviously, where you've got school children being involved, they couldn't be on contaminated land, and the conduct was misleading or deceptive. So that is the issue of silence. Turning now to the other kinds of issues that we covered off in misrepresentation, things like representations of fact or law. Now, misrepresentations as to fact or law will be actionable if they are capable of leading that reasonable consumer into error. So no real problems there. Opinion, well, there's been a little bit more debate on opinion. It looks like opinion will certainly be actionable if it suggests that there's some kind of factual basis for the opinion, or if the opinion is not actually held. So you're telling a bit of a porcupine there. Future intention. Predictions, not usually actionable. However, again, if these kinds of things are stated and known to be false, or you're reckless and careless of whether the statement is true or false, then it's likely to be actionable. Under Section 4, very interestingly, there is a rebuttable presumption set up. So statements of future intention will be deemed to lack reasonable grounds for their making, unless the representor can show reasonable grounds. So there's an additional hurdle set up by the legislation for the representor to have to jump over to show that their statement as to some kind of future intention or future state of affairs was reasonable. The last situation is puff, and as we saw with the common law of misrepresentation, usually puff's not going to be actionable. It's just one of those things that salespeople tend to do. However, under the legislation, if the effect of the puff would actually be to lead one of those reasonable consumers into error, then that particular salesperson is going to be in a bit of bother. So in Byers and Dorotea, you had a real estate salesperson talking up a unit that was going to be sold, and the salesperson said that that unit was bigger and better than anything nearby. The purchaser took that for what it was worth and wanted to go through with the transaction. It was not bigger nor better than other units nearby. And in those circumstances where that puff had led the buyer astray, then unfortunately it's going to be actionable puff. So they are the various different kinds of conduct or refraining from conduct in the case of silence that might trigger off an actionable misstatement. Now, in terms of the technical nuts and bolts of things, and here's where we kind of get down to fairly fine level of detail. Things like limitation of actions. Previously, the whole situation was a bit of a mess. Now, with the new legislation, it's been clarified significantly. Generally speaking, you will get a 6-year limitation of actions from the date on which your cause of action accrued. Okay, so you just need to be able to work out when the accrual of that cause of action occurred. And that can be a little bit complicated where you have things like contingencies to worry about in your contractual terms. I'll leave you to explore that issue in the text at your leisure. The other question that the text raises is whether or not a contravention of Section 18 is a criminal offence. The general answer to this is no, it's not. However, there are a number of offences in sections 151 to 152 of the legislation that will actually make a contravention of Section 18 a criminal offence. And we'll just pop over and have a look at those now. And here we are at Section 151. And you can see a person commits an offence that is a criminal offence if the person in TLC in connection with supply or possible supply of goods or services and does any of these things involving false or misleading representations. Goods are a particular standard, quality, value, grade, and so on. Now, if you make any of these kinds of misstatements, have a look at the penalty here. If the person is a body corporate, cool, $1.1 million. If the person is not a body corporate, natural person, so it's either you as the representor or with accessorial liability, $220,000 for each and every offence that you commit. So very serious criminal provisions here. Look also at Section 152, that's in relation to false statements about the sale of land. So yes, misleading or deceptive conduct does have real teeth to it under the legislation. The text does also mention civil penalty provisions under Section 224. They look to me to be mainly about unconscionable conduct, so I wouldn't worry too much about those. But what we do have to worry about is damages. Okay, so turning now to damages, we need to look at Section 236 of the ACL. So under Section 236, you can see here actions for damages, and under 236, the claimant has to have actually suffered loss or damage because of that misleading or deceptive conduct by the representor. Now, here, this is to be contrasted with Section 237. You can get compensation orders under Section 237 on application by the representee, or in fact the regulator. The ACCC can step in and take charge of the matter here. But the loss doesn't have to have actually been suffered. It can just be likely to be suffered. Okay, so small distinction there between the action for damages under Section 236 and the compensation orders under Section 237. Courts will be using, generally speaking, the tortious measure of damages, which is to get that plaintiff back into the pre-tort position that they were in. So again, you're not going to be making money on this kind of thing. You can't get expectation loss generally, so anticipated profits and that kind of thing. The kind of money that you'd be seeking under a contractual claim for damages rather than a tortious claim. The only way that you can get expectation losses is if you can show that but for the misleading or deceptive conduct, you would have entered into another contract and you would have had the benefit realised by way of that other contract. So essentially, you're looking at the lost opportunity kind of measure for damages there. In terms of consequential loss, so the other kinds of losses, business losses, trading losses, and other kinds of losses that might flow from the original misleading or deceptive conduct, you can seek those under Section 236. So that's damages. You do need to establish causation, that the relevant loss or damage was suffered because of the misleading or deceptive conduct. And so obviously there can't be any break in that chain of causation, or you're going to have problems in being successful with your claim for damages. If you're contributorily negligent, then your damages can be reduced under Section 137B and also under Sections 87 capital CB through to capital CI. You can have a situation where you've got co-defendants. There's been a number of different parties that have been involved with this misleading or deceptive conduct that's caused you damages. In that circumstance, the court can apportion the loss between those co-defendants. So that's just the nuts and bolts in relation to damages. I'll leave you to explore the minutiae of the text on those various issues. There are a number of ancillary orders that can be made under Section 237. The court is able, and look at this for a broadly drafted provision, the court can make such order or orders as the court thinks appropriate against the person who engaged in the conduct or was a person under accessorial liability. Now, Section 243 fleshes out that very broadly drafted provision in specifying the kinds of orders that can be made. So obviously it doesn't operate to limit the broadly drafted provisions in 237, however it gives you an idea of what can be done. So an order declaring whole or any part of a contract made to be void, and it can be void ab initio at all times after a particular date, if the court thinks that that is the right thing to do. You can have variations being made. You can have a refusal to enforce, so unenforceability. You can have refunds being made, and so on and so forth. So very useful grab bag of goodies there for a potential plaintiff to get exactly the kind of remedy that they really do need the court to provide them with. So they are the ancillary orders that you can get under Section 237. Now, the last thing that we need to cover off is exclusions. Now, as you can imagine, exclusions are usually given fairly short shrift by courts. They're not looked upon terribly favourably. There have been some successes, but probably they're in the minority. It really does depend on the facts and just how well the exclusion is drafted. Generally speaking, the courts will, as I said, strike them down because otherwise, if you think about it, they could just evade the whole operation of the ACL. So, it's a fairly obnoxious piece of conduct in trying to evade what is essentially consumer protection legislation. So they will just be taken into account as one of all of the various factors in the factual matrix surrounding the case. And if the court, in considering all of those factors, still thinks that there was a real or not remote possibility that the consumer was, in fact, led into error or would likely have been led into error, then you're still going to be caught by the legislation. Entire agreement clauses are sometimes used to try and evade the legislation here. And these are those nice little clauses which simply say, and on signing this contract, I acknowledge that I'm relying on the terms and conditions contained in the contract, and this forms the entire agreement between the parties. I'm not relying on any collateral or pre-contractual representations that were made to me. Sometimes those entire agreement clauses are in the contract itself. Quite often they will be housed in a separate deed. As I said, there have been some successes here. It just really depends on whether those little clauses do actually operate to break the chain of causation and prevent that whole problem of being led into error. So have a look at what the text says in relation to exclusion of liability. I think it's a fairly common sense approach that the courts take. They need to be reasonably strict with these kinds of things. Otherwise, the legislation could be fairly easily sidestepped. So that is misleading or deceptive conduct. And like I always say, if you have any queries or questions, please don't hesitate to email me or send me a tweet or post a message on the Contract B Facebook page. Other than that, I hope to catch up with you in a Zoom session sometime soon. And thanks for watching. Bye.